my learned friend, Ifeanyi Ejiofor, to that meeting. And I then demanded that Nnamdi Kanu should be present at the meeting, because we are only lawyers and we do not know anything about medicine or surgery. And they fetched Nnamdi Kanu, and we all sat down and brainstormed and agreed that there was no way they could have carried out that surgery on Kanu without his own personally appointed medical doctor, a doctor of his own choice, as earlier directed on the 21st of October 2021 by the Honorable Justice Binta Nyako of the Federal High Court, that he be allowed to have his personal doctor so that there could be a second opinion on his deteriorating state of health, wherein they are increasing his potassium level every day. They are using him as a guinea pig for trial because they do not know the cause of his illness. And all the tests they have done, blood tests, urine tests, stool tests, which they have always done, they have sent to South Africa and some other countries. Nnamdi Kanu to date has never been availed of what the results were, nor have we, his counsel. So at that meeting, therefore, I impressed it upon them that there was no way they could carry out a surgery on Nnamdi Kanu's ear without his personal physician being present. And that we will not even allow it. And that was what we agreed on. The meeting was that when Nnamdi Kanu finally appoints any one or two doctors of his choice, they should get across to us. We will now again write to the SSS for an interactive session between these doctors and Nnamdi Kanu, because his earlier doctor, Dr. Sylvain Okorochukwu, who had been treating him even before his extraordinary, torturous and forceful rendition from Kenya back to Nigeria on the 27th of June 2021, who had gone to the DSS facilities 2 times and had been denied access to see Nnamdi Kanu, himself was not in the country. Because of that, it means that whichever doctors that will be seeing Nnamdi Kanu will be seeing him for the first time, and Nnamdi Kanu will be seeing them for the first time. So there must first be that interactive session so that they can have a synergy to know whether these are doctors that he can go with or whether he will need another set. Surprisingly, suddenly, like Fela will put it, we saw flying in the social media some characters saying that the family of Nnamdi Kanu has allegedly debriefed me and Ifeanyi Ejiofor. There are certain pieces of news I don't take serious. I didn't just laugh. I guffawed. It was a loud laughter that these guys do not know what they are talking about. You cannot sit in Germany. You do not know what is going on with your brother's case or his life. And you say that Nnamdi Kanu has been trying since 11th of May to get across to me, and I'll be refusing to see him. Whereas I was with Nnamdi Kanu on the 3rd of June. And the very day you were releasing this text, this social media damnable and defamatory statement, Ifeanyi Ejiofor was physically with Nnamdi Kanu. You release this, your social media something, at 1:57 p.m. 3 minutes before the 2 p.m. when Ejiofor was supposed to meet with Nnamdi Kanu. And he met him. And Nnamdi Kanu sent his personal greetings, happiness, and thanks to me through Ejiofor. And that everything is going on well. He's very happy the way I've conducted his case. Since I came in January 2022, I got 8 of the 15 counts dismissed by this honorable court here, Justice Nyako. The remaining 7 counts, I was dissatisfied. I took them to the Court of Appeal, and on the 13th of October 2022, in a landmark judgment, the Court of Appeal dismissed the remaining 7 counts and gave Nnamdi Kanu a clean bill of health. The Court of Appeal declared that Nnamdi Kanu was hereby discharged. The Court of Appeal declared that Nnamdi Kanu should never again be arrested or detained over this matter. The Court of Appeal went further to declare that never again should Nnamdi Kanu be tried on the same offenses for which he was extraordinarily, torturously, and extrajudicially renditioned back to Nigeria from a sovereign country, Kenya, where he had gone to in May 2021 as a British citizen, not even as a Nigerian citizen, without following the extradition process. And a whole federal government, rather than defend its citizen, as the American government will do, they will go to any country to go and take out one of their citizens. We have seen it again and again. The whole federal government filed a motion for stay of execution of the liberty of his own citizen, contrary to section 36 of the Constitution. An unknown process, and another panel of the Court of Appeal granted that stay. They filed an appeal to the Supreme Court and they sat on it. They refused to prosecute the appeal. They will file papers, they will not serve us until we go there by ourselves to search. The federal government has been running, but by the grace of God, they cannot hide. On the 14th of September 2023, this case will come up before the Supreme Court. Nnamdi Kanu will secure his freedom. The Court of Appeal made it clear that the acts of the federal government were egregious and they breached Nnamdi Kanu's fundamental rights. And he should never again be detained or tried on the same offenses. The federal government has not abided by that decision. The federal government has not abided by the ruling, the judgment of the United Nations Human Rights Panel against detention, which was made in July 2021, that Nnamdi Kanu be released, and not only released, he should even be compensated for the degradation and violation of his human rights. The federal government has not abided by the African Union own ruling that Nnamdi Kanu should be released. The federal government has not abided by the decision of the Umuahia Federal High Court, sitting at Umuahia, that the detention of Nnamdi Kanu was illegal, unconstitutional, and that he be released immediately, and indeed awarded 500 million naira damages against the federal government and in favor of Nnamdi Kanu. They have not abided by that decision. They continue to go to play the same roulette like a yo-yo, that Nnamdi Kanu jumped bail. And evidence available shows that Nnamdi Kanu did not jump bail. That when he was arraigned on the 23rd of December 2015, this court, Justice Binta Nyako, granted him bail. On the 25th of April 2017, about 1.5 years later, Nnamdi Kanu was enjoying this bail in the country, in this place called Nigeria. He did not jump bail until the federal government by itself, going through a most satanic operation, Python dance, to invade Nnamdi Kanu's ancestral home at Afarauku, Ibeku, Umuahia, in Abia State. And in that operation, non-provoked operation, they mowed down, they killed 28 unarmed and innocent Nigerians. Nnamdi Kanu barely escaped with the breath of his life by providence, by an act of God. the father, Ozekhome, never recovered from this atrocious, inhuman invasion. He died. And the mother never recovered, and she died. So Nnamdi Kanu first found his way to Rome, to Israel, where he quickly deposed to an affidavit saying, I have run here for my dear life. If the federal government can give me protection, I'm ready to return to Nigeria to face my trial. He deposed to it. The affidavit is before this court. So for the avoidance of doubt, Nnamdi Kanu never jumped bail. Rather, he was forced to flee for his dear life in Nigeria. Because if he had been killed in that same operation where 28 innocent Nigerians were killed, we won't be here today talking. The law says, the Supreme Court, is that you should come and stand trial. To come and stand trial means that you should be healthy enough, you should be alive to stand trial, because dead men don't stand trial, only the living. And for you to stand trial, it means you must stand in the dock. That presupposes that you are healthy. So the Lord has never said, come and sit down trial, or come and prostrate trial, or come and be wheelchaired trial, or come and lie in a hospital bed trial. He says, come and stand trial. And then Nnamdi Kanu has to be alive and be well to stand trial. And the same federal government, the same SSS, that forcibly renditioned him from Kenya to Nigeria on the 27th of June 2021, a country, a sovereign nation Nnamdi Kanu had visited as a British citizen, not as a Nigerian citizen. He was abducted, captured, kidnapped. He was tortured. He was blindfolded. He was put in a decrepit, isolationist camp, not a federal government facility, for 8 days before they brutally renditioned him extraordinarily back to Nigeria. And that is what the Court of Appeal said you cannot do. That is against local laws, against the Extradition Act, against all international laws, against United Nations Declaration of Human Rights of 1948, against Indigenous Peoples' Rights Law, against the social and economic laws that are applicable, against the African Charter of Human and People's Rights. The court declared it so. And Nnamdi Kanu is still being held today in isolation. He's not allowed to practice his Jewish religion. He's not allowed to interact with other cellmates. In fact, when he greets some detainees, those detainees are quarantined off in some more dangerous gulags as punishment for exchanging greetings with Nnamdi Kanu. So, he's there being tortured, dying by his torments, apart from the ear surgery we are now requesting for. Dying, mentally tortured, physically tortured, spiritually tortured, psychologically tortured, psychically tortured, his humanity being degraded on a daily basis by a federal government that ought to protect its citizens. What has Nnamdi Kanu done wrong? Nothing. No court has convicted him of doing anything wrong. All he has done is to say, you must give the Indigbos, his own Igbo people, a space in Nigeria like other Nigerians. Don't marginalize them. Don't see them as a mere speck or a mere dot in the larger cycle of Nigeria. But however, if you will not allow them this respect, this dignity that you accord to other 373 out of 374 ethnic groups in Nigeria, then let them go on their own to found their own Republic of Biafra. We call it self-determination. Self-determination is is giving legal imprimatur to bar all international instruments. All international says you can have self-determination. And that was how IPOB was born in 2012 as a non-violent organization. We saw them on the streets of Aba, of Onitsha, of Enugu, of Owerri, and other southeast states, marching on the streets, carrying cudgels, clubs, wearing beret, blowing whistle. We are for Republic of Biafra. They did not do anything that was dangerous or that was treasonable or that could harm the country, as an entity. So, but the federal government found it using the army, they could quickly form Operation Python Dance. Operation Python Dance, which has not danced against Boko Haramis, which has not danced against armed bandits, which has not danced against kidnappers that have since been on the surge. But they could go to attack this young man in his hometown, and thank God he's alive today. If he were not alive, we wouldn't even be here discussing this matter. So the federal government, the SSS, they are wrong, and they are wrong. And today, the court has had us asking for an order of mandamus, compelling the SSS to provide his medical records. If you have nothing to hide, what harm does it bring to you to provide Nnamdi Kanu's medical records for us, his lawyers, to see? We are also asking for an order of mandamus that he should be allowed to see his personal physician, as ordered by this same court on the 21st of October 2021. What has he asked for that we hurt the federal government? How can you be the person, the agency that arrested, forcibly renditioned him back from Kenya to Nigeria? You are the same agency detaining him. You are the same agency that investigated him. You are the same agency prosecuting him. You are the same agency again detaining him. You are the same agency opposing his bail for application. You are the same agency opposing his application to be transferred, at least from your gulag to the Kuje Correctional Center, which is a place meant for people who have been granted bail, as was his case. So they have become not just the judge and the prosecutor, they are also the arrestor, the detainer, the prosecutor, the investigator, the judge. And you cannot run a country like that. SSS, listen, and listen good. Abide by the order of the Court of Appeal made on the 13th of October 2021. Let Nnamdi Kanu go. Release him. Let my people go. Moses told the Egyptians, let my people go. They will not hear. He was with his brother Aaron. Am I right? They will not hear. And Pharaoh, the Egyptian emperor, brought magicians. Anything that Moses conjured, they will conjure to show their power, the power of man. But it was God in action. Go and read Exodus 8:19. The finger of God. When the camp of Moses conjured little lice in the head, those small insects in the head. When they conjured them, the Pharaoh Egyptian magicians tried to also conjure the same gnat, the same lice. They could not. And that was the smallest of all the feats. They went back to Pharaoh and said, this is the finger of God. Let these people go. But Pharaoh was already deafened. He will not hear of it. When the Israelites were going, God parted the Red Sea for them to go through. And then the Pharaoh army with chariots and charioteers, they came steaming, pursuing the Israelites. And God closed the Red Sea for them. And they drowned. This is a caveat to the federal government. Don't let this Nnamdi Kanu drown us as a people. We do not need it. It is an avoidable happenstance. Let the federal government, let the SSS release Nnamdi Kanu today. And I believe that by the grace of God, the court will do the needful. We grant our application for an order of mandamus. And they had tried to raise funny preliminary objection that the case is like another one decided by the Honorable Justice Taiwo O. Taiwo, who has now retired. We have been able to demonstrate and show that the two cases are different. In that case before Justice Taiwo Taiwo, there were 3 parties. In the present case before this court, there are only 2 parties. The case before Justice Taiwo was the enforcement of fundamental human rights. The case before Justice Nyako here is for an order of judicial review to grant an order of mandamus. We showed thirdly, the case before Justice Taiwo had 11 reliefs. 11 reliefs. 6 declarations and 5 orders. The case before this court, where we are here, is just 2 orders. An order to grant him access to mandamus, to have access to his doctor and his medical records, and further order. That's just all. So we've been able to show that both the parties, the reliefs, the subject matter, and the goal are different. And then in such a case, the doctrine of estope perem judicata cannot apply. We believe that the God of that same God of Israel, that same God of Daniel, that he delivered from the den of lions, that same God of Paul and Silas in Acts of the Apostles, chapter 16, that same God of Meshach, Shadrach, and Abednego, that same God of Lazarus, that Jesus Christ woke up 4 days after he had died, and his flesh was already decaying and stinking. That same God of Noah and the ark, that same God of Jonah that was in the belly of the fish, that same God of Jesus Christ that died and resurrected the 3rd day, that same God is alive and well. He slumbereth not, and he does not allow injustice to be perpetrated unremedied. By the grace of God, Nnamdi Kanu will get justice through the courts. If the federal government does not see the wisdom of quickly releasing Nnamdi Kanu as urgent as yesterday, releasing Nnamdi Kanu will not endanger the country. It is releasing Nnamdi Kanu that will actually bring peace and tranquility to the troubled southeast region. I've held several meetings with Nnamdi Kanu in his presence, and he laments that his own people that he is defending are being made by some characters to sit down at home every Monday, not to go to work. He has asked me that question again and again rhetorically. Chief, sir, how can I, who is helping my people, how can I be the person to be again punishing them by saying that they should not trade, they should not thrive in commerce and industry, which is their main area? I am not party to it. I want to come out. When I come out, I will address my people so that they will know that there's no need to kill their economy, to kill themselves. Nnamdi Kanu is non-violent. He has never used violent means to attempt attaining his goal of self-determination. So the federal government, to me, if they are wise enough, if it's wise enough, they should just let this man go and release him. That would be more productive. That will have multiplier positive effects but his continued incarceration and detention will continue to be like a whitlow on our forefinger. And for as long as you allow the whitlow to go on, it will ache you and you will not be able to sleep. So if Nnamdi Kanu is not sleeping, the federal government itself is obviously not sleeping, because this has become no longer a national case, but an international case in which the United Nations had made interventions. The African Union, the European Union, all over the world. This case is a case. The federal government should do the needful and order the release of Nnamdi Kanu as urgent as yesterday, without even awaiting the Supreme Court decision coming up on the 14th of September 2023, without even awaiting this judge's decision coming up in July, on the 20th of July. If they do that, the federal government will gain mileages and mileages of acceptability